Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna, PC, immigration.com. This is our two weekly community conference call. People post their questions on the forums, we answer them, and anybody is welcome to call in. That said, we're going to get started as we normally do. I will first answer the questions that have been posted. Then we will do follow-ups on the questions that have been posted, and then we'll take the new questions from people, if there are any new questions, in the order that people logged into the community conference call. Okay, that said, let me begin with the first question. SK1976123. I have an I-140 related question. I work for employer A who filed my PERM application, got the I-140 approved. 6 years are gone on H-1B. Seventh year extension on the basis of PERM took longer than 365 days to get approved. Now I've got an offer from employer B and I wish to move on. I heard rumors that I need to be 180 days with the employer. No, you have misunderstood. The way it works is, there are three things you need to be worried about when you are moving from employer to employer. Number one, can you carry your priority date? And the answer is absolutely. The priority date can be carried over to the new employer as soon as the I-140 of the old employer is approved. Number two thing is, can I carry my whole green card over without having to redo the green card? That's where the 180 days kicks in. Your I-140 should have been approved and 485 must have been pending 180 days. If you meet that requirement, then you go through something called AC-21, American Competitiveness in the 21st Century Act, and you move your whole green card over to a same or similar job to any employer in the United States. You don't have to redo the green card. And the third thing you have to worry about is your H-1 extension. Okay. So once again, once the I-140 is approved, no question, without waiting even a day, your priority date goes with you. If the I-140 is approved, 45 is pending, 180 days, the green card goes with you to a same or similar job without having to redo anything. But for you to have an H-1 extension, on the date the H-1 extension is approved, your I-140 should not have been withdrawn. If the old employer withdraws or revokes your I-140, they cannot touch your priority date. That still remains yours. They also, if you qualify for AC-21, cannot touch your AC-21. But they can influence your right to get further H-1B extensions. So that means move to employer B, no problem. You'll have to redo the green card. You'll carry the same priority date. But make sure you don't join the new employer until the H-1 extension for 3 years is actually approved. Because I'm concerned if you leave the old employer before the H-1 approval, they can revoke the I-140 and that would cause problems in getting further extensions. Okay. Once you get your 3-year extension, government is not revoking extensions that they've already given. Okay. I hope that's clear. Next question is PRPGRL, who wants to know about H-1B quota. How does the USCIS decide when they stop accepting H-1B applications? Well, they keep track on the number of the H-1s they have received, and when they have received more than they think they can process, they stop accepting new applications. Okay. Will they disclose how many applications they received in 2014? Of course, they've already disclosed it. I think it's what, 173, something like that, 173,000. If so, when it's already disclosed, they have disclosed the number. If they only accept applications till they reach the cap, they should not have to conduct the lottery. That's a very good point. But the logistics are that there is no way for them, I mean, unless they created some kind of a counter of some kind at their mail center. They get dumped with all these applications. By the time they get entered into the system, the applications, once you file, don't get entered into the system right away. It takes them a day, 2 days, 3 days, 4 days to enter them in the system. Okay, so it's not possible to have that kind of mathematical certainty right now. I'm sure they can implement a process, but right now their process does not accommodate for stopping right when they get enough number of applications. And by the way, how do you determine enough number of applications? That's one thing that's always bothered me, because there is a high rate of denials also. Even if you go through the lottery um, and your case is denied, what do they do with those cases that they're denying? As far as I understand, they never get utilized again, not for that fiscal year. So yeah, there are some issues here, and if I'm wrong, please correct me, but that's my understanding. If there are issues with this system, but this is how they are working it right now. I hope that answers your question. Okay. So next question is from Dame Pirate. I have an EB3 I-485 pending, filed EB2 with new company, I-140 approved with priority date being ported. If EB3 priority date becomes current before EB2, can I continue with EB3 I-140 485? The answer is yes, as long as the job is available. Do I still have AC-21 privilege? Of course you do. Of course you do. Even if you have EB3 or EB2, either one, you have AC-21 privilege for both or either one of the cases. Deep Mapped wants to know, I had L1B, wife had L2. She applied for H1B, got RFE. She went to India, came back on L2 on January 21st. Okay. After her coming back, her H1 got approved. Well, she's on L2. Why? When you leave USA while a change of status is pending, that change of status is abandoned. So even though her H1B was approved, her change of status could not be approved because she left USA while this case was pending. So I don't see any problem. She's on L2. Okay, once again, H1 was pending. She goes to India, comes back in January. 2 months later, her H1 gets approved. Question is she on L2 or H1? She's on L2 because first she left USA while the change of status request was pending. So even though the H1 is approved, the change of status cannot be approved. When she came back on L2, she's still on L2. So I don't see any problem with that. Can she work on L2 EAD? Sure. She can still use the H1B petition if she goes, gets it stamped, and starts working on H1. She can apply for L2 EAD, but I think L2 EAD would be the better option for her. If she decides to activate the H1, she'll have to file either change of status again or go outside USA and come back on H1 visa. I hope that makes it clear. Rahul wants to know, for a friend of his, got a master's degree from a US university, accredited US university. Then what happens is, started a volunteering unpaid part-time job, 25 to 28 hours per week, for her own department. And that's documented. Good. Now the problem is she also has a second part-time position in which there is a connection, the connection between the degree that she was doing and the job is a little bit distant. Okay. So, by the way, Rahulji, there is no restriction against working beyond 40 hours on OPT, by the way, just for your information. So when she found out that this second job may not be considered to be appropriate for OPT, she quit after just 4 weeks. I think she'll be okay. Okay. I think she'll be okay. Of course, USCIS can try to create an issue if it comes up. But this is such a small period. I would argue that this is something called a de minimis, which means a very little violation of status. Of course, status can be a zero-sum preposition. You either have it or you don't. But in my view, this is not going to be a big problem. That would be my best guess. Okay. Petra wants to know, company has applied for H-1B for this fiscal year, regular processing. As per our understanding, all receipts get sent out before any processing starts. That is correct. This is why I expected to find out if I was selected in the lottery at the same time as the premium processing applicants. Well, yes and no. The reason is, by the way, right now USCIS is not doing premium processing. They are starting on the 28th, I think. But because the premium processing receipts are sent via email, the people who applied for premium processing find out a lot quicker, even though the cases are not being premiumed. That's my understanding. I don't have Anna on the phone with me from my office. She could clarify, because we have received receipts on the premium processing cases via email already. Okay. If it's important, Petra, send me an email. I can double check for you. My email is help@immigration.com. I'll double check with Anna about did we receive the receipts through email. I'm pretty sure we did. Okay. So the next question is from Cruz Pats, who's got actually several connected questions. Oh, I'm sorry. Petra, you had some other questions. I forgot. I have an offer for a job at my home country as a backup. And you have to respond to that by the end of April. Excuse me for a second. Given that I applied with regular processing advanced degree, can I find out about my application by the end of this month? I don't know the answer to that question. Can the attorney call and find out? I don't see how they would do that, Petra. I don't think they can. Okay. So really, premiuming was the way to go if you needed an early answer. Can you premium it now? I don't think it's going to make much of a difference. So sorry, not too many good suggestions for you. Cruz Pats has a bunch of questions. Let's see what we can do. Nephew applied for citizenship with English and civics waiver. Now they want to do it again, but they don't want to apply for a waiver. Is it okay? I don't see any problem with it. Cruz, if you have any doubts about that, I don't know of any reason why you have to get a waiver again. They can go without a waiver, but you can always call USCIS customer service. Personally, I don't see any problem at all. Second, nephew is 24 years of age. Do we have to register for selective services? Yes, you do. Anybody who is in the United States between the ages, I think, of 18 and 25, as a green card holder, as a refugee, there are a bunch of other things. I think it's refugee, political asylee, green card holder. If you are here between the ages of 18 and 25, you must register. Third question, uncle's green card expires December 2014. If we apply for renewal, can he travel? Yes, they can. What is the temporary proof? You can have them take the passport to the local office with a InfoPass appointment, and basically at the InfoPass appointment request that I have a green card renewal going on. Here is a receipt. Can you please stamp my passport? Then USCIS stamps the passport, and it'll say something like temporary proof of permanent residence, usually good for 1 to 2 years. Last question is, second nephew is also eligible for N400, which is naturalization. He got his green card before 14, did not renew it. Current green card expires in December 2014. Is it okay to file for N400 without renewing? Yes, yes. you can apply for naturalization without renewing the green card. Isha wants to know, can I change employers in my 7th year of H1B? Current employer applied for the 7th year extension, which is good till September 2014, on the basis of a pending perm filed a year ago, which is right now in appeal. Do you see any challenges in the H1B transfer and concurrent 8th year extension till September 19th, 2015? I do not. Even if it is done by a new employer. Okay? But you should make sure that two things are done, Isha. Your new employer should start their green card for you as quickly as possible, even before you join them. And because you are quite sure that the old employer will withdraw the appeal, you should make sure you don't join the new employer until the timing is just right, so that the new green card process has started in a way that will get you further H1 extensions based upon the new employer's green card filing. And you don't join the new employer until your H1 is actually approved. So two things you've got to worry about. Mahesh wants to know, I worked for employer A for 2 years till 2013. They applied for H1, got approved in May 2013. Did not go for stamping, so I guess you were outside USA. You resigned employer A and joined employer B. Now I want to apply for new H1B for employer B. You got the receipt number. Question is, can I apply for H1B with cap quota exemption? And the answer is yes. We have done it with just the receipt number. Even if you don't have the approval, if you are sure that the case was approved, I think you should be able to use just the receipt number. You should be okay with just the receipt number. Mr. Bhati says, I am on the 9th year of H1B visa and working for an IT consulting company. Here's the problem I have with your situation, Mr. Bhati. Or Ms. Bhati. Oh, actually, it is Ms. Bhati. No, it is not. Oops, sorry about that. Your employer, and I think I've mentioned this last time also, your employer has a policy of benching. Benching is illegal. I've told you before, and I'm not sure why we have the same questions again. Once you're with an employer who's benching you, you know they are breaking the law. I would like you to get out of that situation. Okay. Your problem is your current project is expiring in May. How do you handle the extension? And the answer is, if you premium it and you try to conceal the fact that the project is only good till May, that's a problem. That's a fraudulent misrepresentation. You can't do that. I personally think you really don't have very good options. Maybe apply for a tourist visa, and there is a write-up on my blog about that. Apply for a tourist visa and try to stay in status while you look for another job. I don't like the fact that you have an employer who is putting you on bench, and that's just wrong. It's illegal. Okay? Unless they are paying you your full salary. Do we do a premium processing? I answered that question. What happens if I'm on bench? I explained that to you. Should I do regular processing? I don't think an H1 extension can be applied without a project. Government considers that to be criminal fraud. I've had to defend companies or help Criminal Defense Council defend companies that filed H1s without a specific project, and government actually created criminal cases against these companies. One of the counts of the criminal charges was that they applied for H1s without specific projects in hand. So no, you can't do that. How many days does USCIS give for my employer to respond to RFE on client letter? Well, on the date the H1 is applied for, the project must be in hand. If the project comes in hand after the H1 is applied, it's uncertain what they are going to do. Okay. Urs Gemini wants to know. My wife was on H4. She got H1 approval and was good to go from October 2013. She wanted to go back to H4. She applied for H4 again in November. Now she has an RFE saying prove that you had maintained status. I think the only thing you can argue with the government is that under the Department of Labor regulations, if an employee is already in the United States, they have 60 days to join the employer. It's a little bit more complicated than that, but that can be argued, and that because of that, she should be considered to be in status, even though it's not USCIS regulations. You can argue that, or then otherwise she can go for H4 visa stamping. You have an RFE, argue that. Of course, you don't have pay stubs because she didn't join. Okay. So argue the fact that this was not something she did deliberately. For personal reasons, she could not join. And in any case, under the Department of Labor regulations, they permit an employer to start the relationship within 60 days of the H1 approval. In this case, I would argue H1 kick in, which is October 1st. And argue that, maybe that will work. Isha, one of her friends is on 7th year H1 extension. She also has a certified perm from a future employer, which was filed before her max out date. And 365 days before. So in other words, the second one, I'm a little confused about what you're saying. I'm assuming what you're saying is that the second labor cert perm is also good to get her further extensions. And the answer is sure. If during the pendency of during the continuation of the first H1 7th year extension, the second perm has now also been pending 1 year, 8th year can be obtained based upon the second perm filing from the employer who wants to now process her H1. Okay. So I'm not quite clear what you asked me, but I think that's what you asked me. And you cannot get a 3-year extension until an I-140 is approved. Cross-chargeability issue from Pratap 123. She's married to a lady born in Nepal. She's on a student visa. Definitely you are eligible for cross-chargeability. Okay. Because your wife was born in another country, she doesn't have to be on H4, even though she's on F1. But as long as you are married to her, you can apply using cross-chargeability. Your second question is, previous employer filed for a labor for a business analyst. Can they file an I-140 for you using pre-approved labor for someone else? You cannot. Labor certification substitution has been discontinued for the past, I think, 8 years or so. So no, you cannot substitute people on labor certs. Reddy 47 applied for H1 under regular quota, got receipt. Oh, so regular quota people are getting receipts. Good. I have a master's degree in USA. Recently updated my service details. She congratulated me on H1 being picked up in the lottery. Are people eligible for cap even though they applied in regular quota? Of course, of course. As long as your application was picked in lottery and your employment authorization for OPT goes beyond April 1st and you apply in a timely manner, you are entitled to cap extension up until October 1st or the date of the decision on the H1, as long as but you're entitled to cap extension even if you're under regular quota. It doesn't matter whether you're in master's degree quota or regular quota. That is irrelevant. Everybody is entitled to cap extension. Karthik underscore P123, working for an IT consulting company at client A. Employer applied for H1B extension in March 2014 based upon approved I-140 and used client A's paperwork. Joining client B in a different state. Question: if there's an RFE from USCIS for client letter from A and I've already started B, would they accept client letter from client B? No, they will not. It becomes very interesting when you have, let's examine this case. It's a common situation. So you've got an H1B pending based upon a project with client A. The project gets terminated or ends and you file for another extension and transfer to client B. In approving the B case of H1, USCIS has 2 or 3 choices. One, they can say, no, you are now out of status because the previous case was not approved. You have to leave USA, get visa stamping done. We'll approve the H1, but go get visa stamping done. In many of our cases, as I remember, what they do is they say we'll approve B as long as you can prove to us that the A case was also approvable when filed. So in the extension of B, it is entirely possible that you would have to submit the client letter of A showing that the old case was approvable, as well as client letter from B. Another topic. I-140 is approved. I'm on 8th year of H1B working for employer X. X applied for H1B extension based upon approved I-140. Let's say I obtained 2-year H1B extension with my current employer till 2016. Can I use this extension from employer X and go to Y, or does new employer Y need to file H1B extension based upon my approved I-140? They should file it based upon approved I-140 because the government is going to check, Karthik, whether your I-140 is still, it's not been declined or withdrawn. Okay, so every time you file an H1 extension like this, my understanding is government looks at your I-140. You cannot stand on the strength of the previous approval alone. IVT 643 came to US on May 2006. Got H1B approval on approved on May 2007 for the fiscal year 2008. Changed status back to H4. So I assume you were on H4 before. Okay. So now I want to work. Do I have to wait for new H1B quota? You do not. You do not. Because within the last 6 years, you have been approved. You have been approved for H1. So my only concern is, you said you were approved on May 2007, but the fiscal year 2008. So within the last 6 years, you've been counted. My best guess is you should not be subject to the quota. But there's some confusion here, and I don't think USCIS has ever made it clear. The confusion is, there's a bunch of points on which there's a confusion. The phrase approved for H1 in the last 6 years, what does it mean? That's a little shady. Too many ifs and buts, but I think it's worth a shot trying to apply being exempt to quota. Does the H4 period count towards those 6 years? It does not. If I don't come under the quota, I'm assuming you don't, I'm guessing you don't, can I change back through to H1 for a different employer? Yes, you can. At least you can try. My concern is, what does that phrase approved within the last 6 years mean? Not sure. Not sure. This is a little fuzzy. Because if you were approved in May 2007 and USCIS wants to count that date as the date of approval, then it could be said that you've not been approved in the last 6 years, because now we're in the 7th year. May 2007, April 2014. But if we were to say the fiscal year was 2008, but then we'd have to count this as the fiscal year 2015. So it's a little dicey how they count this. Worth a shot, try it. Gen Help 2014. Wife is a green card holder 5.5 years back. Is back last week to USA. Okay. She was in India for 5.5 months. She meets the requirements for citizenship. The 3-month residence rule states that she should be staying in the same district. Can she apply for naturalization now, or should she wait? Samir, the problem here is there are a couple of things here that are again not clear. Since she was only gone 5.5 months, could it not be argued that she is still domiciled or still in the same state as you live? Your home is together. So that's one argument you've got. Second argument, which is very interesting, is that many times, and this is inconsistent, practice differs from region to region, office to office. Many times, USCIS allows you to accumulate the 90 days while the N400 is pending. So if I apply today, because the N400 was pending 4 months or 5 months, they say, fine, you meet the requirements because it's been pending already and you are staying here for 90 days, over 90 days. Best thing is, contact your congressman's office, explain to them the situation, and if you don't know how to do that, just do a search on immigration.com and type congressman. You should be able to pull up a video on how to contact your congressman's office. Okay? So personally, I think she would qualify, but double check. Worst case scenario, you'll have to apply again. Next question, I think we have just 2 more questions left, and then we'll start with follow-ups. And then after follow-ups, we'll do the new questions. Yet another wants to know, son is a US citizen filed for my green card. He's separated from his wife, but there's a case going on in India against them, both son and father, and I'm assuming your father or mother. So the question is, we didn't know when we filed the N400, indicted, convicted, cited, charged, that question. But now that we know, how do we handle it? Of course, you got the right idea that you've got to tell them the honest truth, that when you filed, you did not know there was a case going on. Now you know. Can it have negative impact? It can. They can keep the case pending until you get more information, something that shows what kind of crime it is, whether it's been dismissed or not. So yes, it can cause a problem, but I don't think you have a choice. Okay. Last question, G. Term Act. It says, I have an L1A, recently got H1B from a different employer. Existing company started applying green card. Probably they'll do a EB1 for me. Can I wait for a few months to see if they start my green card, or do I need to switch to H1B immediately? Yes, yes, yes. The problem is, most likely, your H1B was applied with a change of status. If it was not, there is no problem. You need to check with your lawyers. So, Jitendra ji, check with your lawyers if change of status was applied for. If it wasn't, then you have no problem. But if it was, then you are on H1B. What you need to do is, and one thing you didn't tell me is, are you subject to the quota or not? I'm assuming you are not. So then what you need to do is go outside USA, come back using L1A visa stamping. You are back on L1. Then there is no problem. Okay? Alright, let's do the follow-up questions. Anybody who has a question, follow up on what we have discussed. Not new questions. Follow up. Press *5 on your phone, please. *5. One question. Okay, it looks like we have only one follow-up question. I'm assuming rest will be new questions. No problem. Um,
Hello.
Virginia, go ahead, please. Yes, sir.
Hi, Mr. Khanna. Question 12.
12. One second. Okay. Wife was an H4. She wanted to go back to, yeah, the 60-day problem that I discussed. Okay, yeah, go ahead.
Yes. Yeah. So I want to say, I'm like, do you want? Like, it would be better if I contest again, saying that I have 60 days, or better come back to
Let's
stand on
do let's
H4.
let's let's do a cost benefit analysis. If you wanted to hire a lawyer to respond to this, it's going to cost you money. Instead of spending money on a lawyer, I would rather have her go and get her visa stamping done. Okay?
So on what basis? Like, if she goes to India, like for her H4, on what basis H get approved, right? So she needs to
It
show
doesn't
only my H1 copy.
it doesn't matter. You can always apply for an H4 even though the H1 was approved. She just needs your read the consulate website what they ask you to bring. For H4, typically your receipt and your marriage certificate is all they will need.
Or can she use her H4?
That's, H4 does not need an approval from USCIS. She just needs a visa stamp.
Based on my papers?
Yeah. Does she currently have an H4 visa on her passport?
No, not as her approval. She has her H1, H4 approval till December 2015 based on my H1.
Okay, no, you're not following my question. Does she have an H4 visa stamp on her passport?
No.
Okay. Then she needs to get an H4 visa stamp, and the fact that her H1 is approved is no problem for issuance of an H4.
And she won't be considered as out of status, right? For the period, like, or whatever the period.
She will be considered out of status, but that is not a bar. That is not a bar on getting an H4 visa. No problem. Okay, being out of status is not a bar for H4 visa. It can be a bar for tourist visa, for F1 visa, for J1 visa, but not for H4 visa.
So what if the consulate, they are that I'm like, there is an RFE going on your H1 to H4, so
Tell the truth. There is an RFE going on, and we don't have a response to it because she didn't join for whatever reasons. And she was advised by a lawyer to go get her visa stamping done. That's the truth. Always tell the truth.
yeah, that's the truth, yes.
That's all you do. You tell the truth. Okay?
Okay, sir, thanks a lot. Really appreciate your help.
Good luck. Okay, I guess we have two more hands. Um, West Virginia, go ahead, please. No, not West Virginia. Sorry. Illinois, go ahead, please.
Hey Rajiv.
Hello.
Hello.
Yes,
Hi
ma'am, I
Rajiv.
can hear.
This is regarding a question 17.
17. One second, ma'am. Question number 17 was change back to H4. So the timing, how do we count the timing? Are you subject to the quota or not? Yes, go ahead, please.
Yeah, my question is, if I want to change back to H1 through a different employer, will I be needing any pay stubs?
No, you will not.
Okay.
All right. Good luck.
So it's just a conversion of H4 to H1.
That is correct. The issue here is only whether you meet the requirement of the law for being quota exempt. Pay stubs is not an issue at all. Don't worry about that.
Okay, so it's worth a shot.
I think so. I would like to take that shot. Okay?
Thank you so much.
You're welcome.
Thank you.
Bye bye. Okay. I guess we still have two more. No problem. I'm going in the order that people logged into the conference, okay? So This question is from New Jersey. Go ahead, please. New Jersey.
I have a new question, sir.
Oh, new question? No, you have to wait. I'm sorry. Okay, just hang tight. Arlington, Texas. Go ahead, please.
Hello, sir. Rajiv?
Yes.
Yeah, hi, Rajiv. Good morning. This is Karthik here.
Hi.
This is Karthik underscore P123.
Sure, Karthik. Good morning.
Yeah.
Go ahead. You had a question?
Yeah, Rajiv. You mentioned about this is about the client letter A and moving to a project B.
Right.
I'm sorry, I meant to say that, let's say I'm working at client A. In next few weeks, if I move to client B, and my company will be submitting client B letter, the manager letter, a new LCA, all the new paperwork. So my question was, if there's an RFP from client A, but by that time I'm already in client B, and my company submitted all their paperwork, like, statement of work and master services agreement and manager letter, everything like that, would that be a problem? Like, would USCIS accept that client B?
They should respond to. Okay, so let's understand the situation. What you're saying is, my H1 extension is applied through project with client A. While this is pending, I move to client B. When the RFE comes, instead of providing A, I have provide B information, and I gave the answer. I said no, they will probably not accept it. They might accept if you prove that A was also available, for whatever reason it got terminated, and so you were approvable through A, and here is B, by the way. They may accept it, they may not accept it. Often they will say, no, this is a totally new project, you have to file another amendment. That becomes problematic because then status becomes an issue. It's not a simple answer. Anything can happen.
Okay, so in other words, you're saying that if there's an RFP from client A, but by the time I'm already in client B, then so they have to do an amendment to the H1B petition saying that, hey, this particular person, Karthik, has moved to client B, and these are the client letter, new manager letter, new client letter, everything. And also they have to prove that.
Yeah, that A was approvable.
And
so normally what we do is, from what I remember, again, I don't have Anna with me. See, we make all these decisions, and then I kind of don't remember all of them. I'm pretty sure what we do is, in a situation like this, we'll file an amendment, okay, stating that we no longer have the project with A, now we are doing the project with B. And if the RFE comes in A, we'll submit the documentation of A, as well as tell them, by the way, we have an amendment pending because the A project is over. That's one thing taken care of. In B, when the RFE comes, we give information about both A and B, so that you can have continuity of status. Karthik, don't try to understand it. It's quite complicated. Have your lawyers call me if they want my answer, because it's not a simple situation. I have to teach you a lot about the law and the way USCIS thinks, and we just don't have enough time for that. Have your lawyers call me. I'll be happy to talk with them.
Okay. Sure, sir. Thank you so much. And also, one other thing, actually, I tried to edit yesterday. I only was able to edit only one. I was not able to post one question regarding, I'm a non-exempt employee. Because I worked in California before, like companies like IBM and other companies. I'm working for a consulting company, like 50,000 employees. They categorize me as a non-exempt, meaning like we are getting paid by hourly basis rather than salary basis. But in reality, we are actually getting paid by salary only, but it's just showing in the pay stub. So my question is, for example, I'm submitting 2 recent pay stubs. So instead of 24 paychecks every year as an exempt employee, now I'm getting 26 paychecks. In other words, my 1 month pay salary, if it was $5,000, now it is showing only $4,000. But I'm also getting the other $1,000 on 25th and 26th paycheck. So my question to you is, if I submit 2 paychecks, which is like $2,000 each, instead of $2,500 to USCIS, and is it possible that they will calculate saying that, okay, this person is getting paid only 4,000 times 12, which is $60,000 instead of 5,000 times 12, which is I'm sorry, 4,000 times 12, which is $48,000 instead of 5,000 times 12, which is $60,000. And LCA is only showing like minimum is 58. I mean,
Hang on.
I hope I'm.
Hang on. No, I'm not clear. I don't understand what is exempt, non-exempt. And I really, Karthik, I have to move on, so I don't have time to go into all the details, minutia with you. As to how much salary is to be paid, how it is to be paid, it is also a fairly technical issue. If you don't have competent lawyers, I would suggest you get your employer to get you through with somebody whom they trust and whom they feel is a good lawyer. This is not an easy question to answer, nor do we have time for me to go over all the facts with you.
Okay, sir. No, I understand.
Yeah, generally speaking, there are certain things they will allow you some latitude with, and some others that they won't. If at the end of the year you've met the full amount, I would suggest just give them the W-2 instead of pay stubs. Okay, that way there is no confusion, no explanation needed. Your W-2 shows that you've got the full amount.
Okay, I mean, in other words, actually, what is the purpose of providing 2 recent pay stubs to INS?
There is no requirement that you have to provide 2. They can actually ask for as many as they want. You can also file, I think I'll have to look at the instructions on Form I-129. I don't think that's a required evidence. You can always provide W-2 of the last year. Okay, but of course they can ask for pay stubs. And if the pay stubs are asked for, you should explain exactly what the discrepancy is and why it is like that. Okay?
Sir, actually, my question is actually...
I'm Karthik, I have to cut you short. I'm sorry. If there's time, I don't think there will be. I'll come back to you. But if you have not posted the question, I haven't been able to address it. There's not enough time. I gotta go on. Okay?
Okay, no problem. I understand. Thank you.
All right, bye-bye. Okay, let's see. All right, guys, I have 2 raised hands right now. Are these new questions or old? Let's find that out. New Jersey, go ahead, please. New Jersey.
Sir, I have asked before also. My H1B is already expired. I am in 7th year. And I'm on student visa.
You haven't answered my question. You haven't answered my. Is this a new question or you've posted already?
No, this is a new question.
Okay, I'm going to put you down. First of all, I need to understand if there's any follow-up questions. Sit tight, please. Okay.
Hi, Rajiv.
Yes. Is this a new question or a follow-up, sir? New question or follow-up?
This is the question number 5.
5. Okay, 1 second. Yeah, I just want to get to the post.
Follow-up question.
Yeah, 1 second. L1B, RFE. Yeah, she went to India while the H1 was pending. Now is she on L2 or H1? I said she's on L2. Go ahead. Go ahead.
Yeah, first week of can you listen me?
I can hear you fine. Go ahead, please. Yes. I can hear you.
Yeah, first week of December, she got L2.
Sir, I've got your
first
facts.
Week of December,
hang on.
L2.
I have read your facts. Why are you repeating your facts? What is your question?
Okay, so she need to work right now on the H1B or she can continue on the L2 for some time?
Absolutely, she can continue on L2. Let me repeat the fact pattern. Her H1 is pending. She's on L2. She travels to India. She comes back on L2 while she comes back on L2. 2 months later, her H1B gets approved. Correct? Am I right, sir?
Yeah.
Okay.
After 1 month, after 1 month, H1 got approved.
Okay.
After 1 month.
No problem. And the answer is she's on L2. Why? By leaving USA, while the L2 to H1 change of status was pending, she abandoned the change of status. Therefore, when she re-entered on USA, she's back on L2, even though the H1 got approved later. No question about it. Very clear law. Do you have a follow-up question on that?
So like if she want to work on H2, H1, like she need to apply for the change of status now.
Exactly. Either change of status or go outside USA, get an H1B visa stamp and come back.
Okay, okay. Thank you. Thank
You're
you.
welcome. Good luck. Okay, guys. I had put everybody's hands down. Anybody who had new questions. Now, anybody who has any question, new, old, doesn't matter, press *5. Any question, press *5, please. 5, 6, 7, 8 new questions. No problem. No problem. 8 new questions. All right. Well, I'm going to answer these 8 and no more, guys. Okay. So let's begin with Florida first. Florida, go ahead, please.
Hello.
Yes, sir.
Yes, Mr. Khanna, this is Satish. I have a problem. I found an abandoned iPhone in DC airport which I took home. Later, Commonwealth charged me with a felony, amended to a misdemeanor, and following, I've been convicted for a misdemeanor and sentenced for a suspension for 30 days, no jail, or jail 30 days if I commit crime next year. I'm
Okay.
innocent and I'm going to appealing back again, which makes the case to start over again. That means no conviction.
Okay.
But my question is, I'm on H1B, and how will this affect my immigration status?
Okay. It appears to me, based upon the facts that you have given, assuming they are all true, assuming that indeed this is a misdemeanor, you have no problem. One crime, which is a misdemeanor, and the actual sentence imposed is not more than 6 months. In your case, it's just 30 days. You are completely free of any problem as long as you don't get another conviction. So what do? Just Google this phrase. Google, Yahoo, Bing, whatever you use. Petty offense exception. Petty, P as in Peter, E-T-T-Y as in small. This is called petty offense exception.
Okay.
You will have no problem. Don't worry.
Okay, just a moment. Like, if I'm working on H1B, if I change my employer right now and transfer my H1B, would there be any chance of rejection or problem in green card process?
Not on this ground. And remember, we have processed thousands, if not hundreds of thousands of cases. I've had many cases with petty offenses. Never a problem.
Okay,
Okay?
never a problem. All right.
Good luck.
All right, thank you, sir.
You're welcome. Okay, let's go to Richmond, Virginia. Richmond, Virginia. Area code 804. Yeah, go ahead.
Yeah.
Go ahead.
Hi, Kannan, sir. Yeah.
Call me
Actually, I
Rajiv,
am
guys.
on-
Please, everybody, just call me Rajiv. Go ahead.
Yeah, Raju. Yeah, I'm on H1 and wife is on H4.
Okay.
I do have my EAD as well as AP, whereas my wife doesn't have because I haven't got a chance to file her 485 application because of the current dates.
Sure.
What if I go to India and come back on AP? What would be the state of my wife?
I think she'll still be on H4 as long as you are still using your H1 to work. There was a memorandum from a gentleman by the name of Cronin. C as in Charlie, write this down. C as in Charlie, R-O, N as in Nancy, I, N as in Nancy. I think it's from 1984. That Cronin memorandum is still good law. You should be able to search for the word Cronin both on our website as well as the forums. I remember that I have put that out in both places. Cronin memorandum says even if you enter on advanced parole, we consider you to be on H1. Therefore, logically, that does not disturb your wife's H4.
Okay. Can you spell the name again? C-H-R-O?
No, not CH. C as in Charlie, R-O, N as in Nancy, I, N as in Nancy. Cronin. C as in
Cronin.
Charlie, R-O, Nancy, India, Nancy. Cronin. Okay?
Okay, sir. Yeah.
Good luck.
Thanks a lot for that.
Oh,
Yeah.
you're
Thank
welcome.
you.
You're welcome. Bye-bye. Okay, the hands multiplied. Guys, stop raising hands. No more. 9 questions more. Okay, let me see how many I can do. I'll try to do as many as I can. I'll try to do all of them. San Diego, California. Go ahead, please.
Hello.
Yes, ma'am.
Hi, Rajiv. Good afternoon. My name is Devi. Let me tell you my scenario in simple words. I used to be on F2 visa and applied for H1 in 2013. Got approval notice of I-797A form in January 2014. Unfortunately, date of birth has printed incorrectly in that form. I went to SSA office to apply for SSN, and they have entered all the details and told me the application has not been verified. So they have advised me to amend it for correct the date of birth. Hence applied for an amendment in the same month. Now in this month I have got an RFE asking for a client letter, which was also the same RFE answered for H1B.
Okay.
And yeah, and now my question is, what visa status I was on right now? And the problem is here, my husband's F1 visa, he has to extend it by this month end. His OPT is ending by this month end, and he has to extend it. So, does he need to add my application as well along with his extension, or I'll be on H1?
This is a very, very difficult question to answer. Okay. I'll tell you why. The problem is, you are definitely in H1. Can you hear me, ma'am?
Yes, Raju.
Okay, then just listen. Don't interrupt me, please. Let me finish what I'm saying. If, first of all, there is no doubt that you are on H1 status, just because there was a mistake in the date of birth should not be fatal or injurious to your status. But you're not working. Does that put you out of status?
Yes.
Okay. Does that put you out of status? And the answer is, it could. It could. It all depends upon how USCIS looks at it. Okay. But if you try to convert to F2, you're going to have more problems. I can tell you the practical best solution that I can see. I think you should stay on to H1, not try to extend or go to F2, and work this out with the government. I think you are close enough to the end. If you got an RFE, that means they're already dealing with your case, and you should get that approval, if everything is in order, fairly quickly. So stick with the H1, don't worry about the F2. I think you're out of status because you're not working, but you have a good reason not to work. Okay?
Okay, Raju, I have another question. My employer is not running my payroll. Does that be any problem? Because he said without an SSN, he can't run my payroll.
Well, that is not strictly true. Without the SSN, they can run the payroll by you can get a taxpayer ID number, which is not SSN related. There is actually some material out there, I don't remember the details, but there is some material out there on how to deal with errors like this. I don't remember off the top of my head. That's something that will have to be researched. But I think, like I said, you have a valid excuse for not working. Hopefully, that should not create a major problem. The worst case scenario is only this. At some point, you may have to go outside for H1 visa stamping. I don't think it'll come to that, frankly. But that's the worst case scenario. So deal with it as best as you can. I really cannot give you a clear roadmap because one does not exist. Okay? I gotta move on.
Okay. If in case my amendment got rejected by any chance, what would be the case? What I have to do then? Then I can make an dependent visa, or
Yes, then
what
you
I
should
have to do?
then you should go outside USA and get a F2 visa stamp and come back.
Okay, fine. And
Ma'am, I have to go. I'm sorry, I can't answer any more questions. Okay, sorry.
okay, no problem.
Yeah, I'm gonna have to cut my time down, guys. Please keep it short. New Jersey, go ahead, please.
Rajesh, my H1B is already expired for like more than 3 months, and the labor is still in audit for more than 1 month. I changed my status from H1 to F1. After 45 days, I raised the service request, and F2 got approved. F1 got RFE regarding financial bank statement. I called USCIS. They says it will take another 60 days. So I just want to know 2 questions. How much balance we need, and if license is already expired for me and my wife, can we use expedient criteria for my F1 status?
How much money you need is something you need to take up with your DSO, because it depends upon the fees, etc., what the school considers to be the minimum living expenses. So I can't answer that question. That's the DSO who will answer that question. Okay. About the driver's license, can that be used in expedite criterion? USCIS has the expedite criteria online. Okay, check them out. I am not sure. I don't think that you can use this as a reason to expedite your F1, but it doesn't hurt to check into it. I do not know the answer off the top of my head. Sorry. Okay.
I have like 3 years and 6 months old kids, and the expedient criteria, the one of the condition says like extreme emergency situation or severe financial loss to company or individual, and I think that's the 2 criteria I can see right now.
I agree. I agree with you. I think you can make it clear that, look, my wife is on F1 status. We have a child. If we have to take a cab everywhere we go, we cannot survive. This is extreme financial loss. On top of that, if there's any emergency with the baby, we need to be able to drive. So try, it doesn't hurt.
Okay, thank you. Thanks a lot.
You're welcome. Good luck. Okay, we have 5 more questions. Let's go on to North Carolina. Go ahead, please. North Carolina.
Hi, Rajiv. The question is about H1B visa.
Yes, sir.
When I was in US on L1 visa, a consultancy applied for H1 petition in 2008.
Okay.
And the petition got approved, but I never used it because I was on L1.
Okay.
And after completing 7 years on L1, I had to return back to India because of 7 years cap limit. Okay. And I came back to India in September 30 last year. So it's been like 6 months in India before my cycle gets recycled for 1 year outside the country.
Hang on, I'm a little lost. Were you outside USA for 1 full year?
No, not completed 1 full year. I just completed 6 months.
So how does that reset your clock?
What was the question again?
I don't understand. How does that reset your clock? You have to be outside.
The reset. That's right. So the reset didn't happen.
So what visa did you return to USA on?
No, I'm not in India. Actually, I'm not in US now. I'm in India. Actually, I'm calling from India.
I see. Okay. So what is your question? Go ahead. The question I have is,
the options to revive the previously approved H1 in 2000, from 2008.
I
So
think it'll be
the
I think it'll be too late by the time your 1 year is over. I think it'll be too late. I don't think you'll be subject to you will be able to get away from the quota. See, there are two separate problems. One problem is quota. We don't even have to deal with that because you have already exhausted 7 years of L1, so you can't get H1 anyway. The only way you can reset the H1 L1 clock is by being outside USA for 1 full year.
okay.
So you'll
So
have to
don't have any options.
you'll have to go under the quota.
Okay.
All
So
right?
there is no option to revive the H1.
No, because you have exhausted the 7 years of L1. That's the problem.
Okay. And in order to go for fresh H1, do I need to complete 1 year outside before applying for it?
That is correct. You cannot apply until 1 year is over. You have to actually wait full 1 year before you can even apply.
Oh, so actually there was no chance for me to apply in this April cycle, right?
That
Because
is
I have only
correct.
completed 6 months.
That is correct. Because in many circumstances, if upon the date your benefit kicks in, you qualify, they might let you apply earlier. But this is one exception. If you have that 1 year requirement to be outside, you cannot even apply till the 1 year is over. So yes, you could not have applied in April.
But by October 2014, I would have completed 1 year because I traveled in September, right?
That
Last
doesn't
year.
matter. That's what I just said. You cannot apply. Okay?
So I cannot apply.
No.
Okay. Thanks for the information.
You're welcome. Good luck, sir. Okay, guys, last 3 questions. So let's go with Florida again, please. Florida?
Rupinder this side. Are you able to hear me?
Yes, sir. I can hear you fine.
Okay. I have 3 small questions. One is, first question is H1B tenure regarding the validity actually. What happens is, I was working with one of the clients and with one ex-vendor, and they got my petition approved for 3 years. Now
Okay.
between this, I switch over the employer and again came back to the same client. Now the vendor is different.
Yeah, got it.
But vendor is basically saying that they cannot go for 3 years petition again. Why? Because they said that client, we need a client's purchase order for that particular period. They are correct on their side, but I wanted to understand, same project, same client with X vendor, how can they approve 3 years petition, whereas Y vendor, same project, same client, they are not approving for 3 years?
The answer is very simple. USCIS is not consistent. Next question.
Okay. Just wanted to know that when is the latest we can file an extension from the date of expiring the petition?
The extension request must be received by USCIS before the current status expires.
So like suppose the petition is expiring in the month of November, then it's good to go with 4 months or 6 months before that?
You can
For the
apply.
extension.
You're now, see, you are confusing the question. You asked me how late can we apply. The answer is as long as the papers are received by USCIS before the current status expires, you're okay. Now the second question is how early can I apply? And the answer is
How
6 months ahead of the date. 6 months ahead.
Okay, all right.
Okay.
All right. And the last question, last question is, these days, how long it is taking for getting a labor approved?
Anywhere from 4 months to a year and a half.
Year and a half?
If you get into audit, supervised recruitment, it can take a lot of time.
If everything goes smoothly, then it takes around 4 to 6 months?
No, not 4. I would say 6 to 9 months. 4 months is very unusual. It has happened in a couple of cases, but very unusual.
Okay. All right, that's it from my side. Thank you so much.
You're welcome. Guys, more hands are being raised. I am getting tired, folks. I'll do my best. Let me see how many I can continue to answer. I'll do my best. Waldorf, Maryland. Go ahead, please. Waldorf,
Hi
Maryland.
Rajiv, my name is Harpreet. I'm calling about case I-130. Actually, I applied for my brother. He's in India in 2008, and I got the denial notice in September 2010. But my address was changed, and I did not receive the denial notice. And I just find out the case was denial. So I inquired them, and they sent me a G639 form to file, and I filed the form last week. So I need to know what, is there any chances I can get those 30 days back? And I don't know the reason for the denial.
I don't remember what G639 is, but typically.
Freedom privacy. They said freedom.
Yeah, but that. Do you know when was this case denied? Do you know which year?
2010.
Okay. Well, what you should do is.
2010.
What you should do is get yourself a lawyer and file a motion to reopen. And the lawyer should explain that. Did you say you had a change of address? You did not inform USCIS?
I did. I informed them in September 20th, 2010. And they were sending me denial notice on September 23rd, 2010. But I did not receive the denial notice.
Okay. I think what you can do is get yourself a lawyer. Let the lawyer explain to the government that you did everything by the book and the case should be reopened. It's definitely worth trying.
Okay.
That
so
G639 is not going to do anything for you.
Okay, great. Okay, so I have to just get a lawyer and
yeah, you basically
what's gonna
get a
happen.
lawyer to file an MTR, motion to reopen, and ask the government to reissue the RFE and give you time to respond.
Okay, great. Thank you very much. I appreciate for your time.
You're
Thanks.
welcome. Good luck.
Thank you.
Okay, let's go on to the next one. California, go ahead, please. California, Morgan Hill, California.
Hi, Rajiv, this is Deepa. Can you hear me?
I can hear you, Deepaji. Go ahead, please.
Okay, my question is, I'm an ITU graduate and I graduated in 2011. We've applied for an H1 which is approved till 2014 January, and then we applied for an extension, and 2 days back I got an intent to denial notification from USCIS stating to revoke my original H1. They're not talking about the extension here, they're talking about the original H1. They're saying they will revoke because my university was not accredited at the time of my graduation, that is 2011.
Yes.
So I have two questions. How can we best answer this? Will I stand a chance if I fight this? Or the next question is how can I get back to status and stay in US?
Okay. Was your H1 approval under master's degree quota?
Yes, it is.
There's nothing you can do.
Okay, so even if I fight, they're gonna deny my H1.
Absolutely. That's been my
Okay,
experience.
so in that case, I'm sorry, please go ahead.
Yeah, that's been my experience, Deepaji.
Okay, so say for example, they've given me time of until 8th of May. So my employer says we have to answer something or other so that we can buy some time. And my friends have suggested me to come back to a student status, probably join another university, but that will require a change of status, and I believe change of status, a decision comes in 3 months. So my question is, what will I do in that period of time? Say, example, May 15th, my H1 gets denied, and change of status will take 3 months. Will I still be legal to stay in US, or do I have to step back?
That's a very
out of the
difficult,
country?
very difficult question to answer. I can, in a couple of minutes, try to sum up the situation. But really, you need to get your employer to help you with a lawyer. This is not something we can resolve in a 2-minute conversation. But here is how it goes. USCIS can take the position that your status was erroneously approved, so you've been out of status for years. It doesn't cause you any permanent damage, but they can decline to issue you an F1 within the United States. They can make you go outside USA for F1. Okay? If I were to argue this case, I would argue you are the guys who made the mistake. Why do I have to pay for it? At the very least, you can convert me back to F1 within the United States. In a nutshell, that's the situation. But keep in mind, from the date they deny or revoke your H1, you will be accruing unlawful presence. If you stay in the United States 180 days past that date and your situation is not resolved, you could be subject to 3-year bar from coming to USA. So keep an eye out on the date past 180 days from the date of the revocation. Okay? So go ahead and try for the conversion back to F1. It should be done within the time that you have. Let's see how it works out. All right?
Okay, Rajiv. Like I'm supposed to get the I-20 within a week, and if I apply for change of status with that I-20, can I stay with the receipt of that change of status request that I post in the United States, even if my H1 is denied?
Okay, I'm not going to be able to deal with this whole question, but I will summarize it for you. You do need, like I said, you need a lawyer one-on-one. I cannot do it in 2 minutes. But here is how I actually have answered your question, but you haven't understood the answer. So I'll answer it again.
I'm sorry.
But this is no, it's not your fault. It's just that it's a complicated idea. I'm trying to explain in a very brief amount of time. Sometimes questions are so complicated that they can't be resolved in the time that we have. So, bottom line, USCIS can take the position that you are out of status, and you have been out of status for many, many years. But does that prevent them from giving you F1 within the US? The answer is yes and no both. If they agree that this was their error and you shouldn't be punished for it, they might give you an F1 within the United States. Your question is, can I stay here? And the answer is yes. Even if you're out of status, nothing permanent will happen until 180 days from the date of revocation of the H1. Do not stay past that point. Okay?
Okay.
Good luck.
Thank you so much. Really appreciate it.
You're welcome. Sorry guys, this can be a little frustrating because I want to answer the question, but I just don't have enough time. And usually if you have posted the questions, then I can allocate the time and I can make sure that those questions are answered. But we try our best. Okay, we've got 2 more questions left. So let's go to Texas. Go ahead, please. Texas.
Hi, Rajiv. I have a question. Last year I've applied for H1B from an external employer, and I got an RFE. And for personal reasons, I had been to India for 3 weeks and returned back in December end on L1A, which was a new visa. So I just wanted to know, recently my H1B got approved, and I wanted to know my current status.
Okay, let me understand this. When the H1 was applied for, were you in the US?
Yes.
What was your status then, ma'am?
L1B.
Okay. So you applied for H1 and then you left, right?
Yes.
Okay. By leaving, you have abandoned your change of status request. It's the same case as the one that I discussed just a few minutes ago. So when you came back, you are on L1A now. Even if the H1B gets approved, and even though USCIS approves the change of status, they should not have approved the change of status, because by traveling, you have abandoned the change of status. So you are back on L1A in my opinion. No problem.
So can I use H1B in future?
Yes, but you'll have to either apply for change of status again or apply for a visa, H1 visa. Okay?
Okay.
Good
Thank
luck.
you.
You're welcome. All right, last question of the day, folks. North Carolina, go ahead, please.
Hi, Rajesh. It's a follow-up question which you just answered. This is regarding the reviving the previously approved H1 from 2008.
Okay.
You did mention that there is no way we can use that H1 now. But I heard that usually approved H1 petition is valid for 6 years.
No,
And,
no. Hang on. Stop right there. Stop right there. H1
Sure.
by statute cannot be approved for more than 3 years at one time, ever. Go ahead.
Okay.
Go ahead.
So maybe I should have said that within 6 years I can use previously approved H1, maybe quota exemption or something like that.
That is correct.
So-
That is correct. The quota is not applicable to a person who has been counted towards the H1B cap in the past 6 years.
Yeah. So since my H1 was approved in 2008, I thought I have still some time to reactivate it before October. Maybe I don't know whether my 7 years cap on L1 is not allowing me to do that. But you said it's not
That is
possible.
the problem.
I just wanted to.
That is the problem. In your case, I told you have two issues. Maybe problem is I think we don't have enough time usually in this conference calls sometimes, and the ideas are quite complex. I'm going to try to sum it up in 2 minutes, then I have to go. I have other appointments scheduled. At 2 o'clock is my next appointment, so I have to leave. The problem here is this. There are two separate issues. I don't even need to get into the quota because you cannot come back to USA until you've been outside USA for 1 year. You just cannot. You exhausted your L1A 7 years. They will not allow you to come back. Quota doesn't matter. Completely irrelevant.
Yeah.
Are you with me so far?
Yeah.
Okay.
Yes.
By the time you're ready to apply, you'll be past 6 years, more than 6 years. So you will not be able to get quota exemption anyway. So therefore, because you exhausted the 7 years, you cannot apply until you've been outside 1 year. And by the time that time elapses, you would not be able to get quota exemption because it's too long, too late.
Okay.
Does that make sense?
Okay. Thanks.
You're welcome.
Yeah, that makes sense. Thank you.
All right,
Thank
guys.
you.
Good luck.
Bye.
Thank you for being here. I will see you again in 2 weeks. Bye-bye.
Thanks a lot. Bye.
Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.